Welcome to the Dealmaking with Laura DiFrancesco podcast. I'm Laura DiFrancesco, your host. We're talking all about mergers and acquisitions, buying and selling small businesses, as well as corporate law. We are taking our experience closing over $10 billion of transactions since founding Dean Street Law 5 years ago, and my experience being an M&A and corporate attorney for over a decade and making it accessible to you as an entrepreneur. I hope that this helps you in navigating the complex world of mergers and acquisitions. And also, we're always happy to be a resource for you here at Dean Street Law. You can always apply to work with us through our complimentary consultations linked in our show notes. And a huge shout out and thank you to everyone who's subscribed and left us a 5-star review. If you haven't yet, be sure to subscribe and also leave us a 5-star review. It's one of the best ways to support us as a small business. And also be sure to share with your friends and colleagues on social media, through text, email, or however is easiest. It means the world to us that you're supporting our content and helps us make more to support you in your journey. Welcome back to another episode of the Dealmaking with Laura DiFrancesco podcast. I'm Laura DiFrancesco, founder of Dean Street Law, your host. We have closed over $10 billion of transactions since beginning Dean Street Law and focus on lower middle market mergers and acquisitions. So whether you are a buyer or a seller, I'm sure employees are at the heart of your considerations when you're buying a business, because a business is not just the numbers, it is the people who make the business. It is one of the most important considerations when buying a business, and sellers likewise have a vested interest, most of them, in making sure that their employees have continued opportunity for employment, as well as care and the same pride that they've built in building their business continuing on in a legacy transition. So today we're going to be talking about how to transition employees, which is different between a stock purchase and an asset purchase. We'll get into further details about some legal ramifications and other aspects of employee transitions from ownership from seller to buyer. With that said, let's get started. One of the first considerations that you have to think about is whether you're doing a stock purchase or an asset purchase, which may not be something that you are immediately knowledgeable of, because sometimes that does require due diligence. But your employee strategy and transition strategy should be at the forefront of your mind if you're a buyer at the LOI stage. Likewise, if you're a seller, it should be included in your LOI if it's important to you that all employees are maintained, that all of their benefits are maintained, etc. So how that's structured is different from an asset purchase to a stock purchase. In an asset purchase, the buyer is buying the assets of the business and then creating a separate company to hold those assets of the business. And sometimes that's the same company that will then be employing independent contractors and employees of the business. So in that case, the transition is actually more significant because employees are actually transitioning who they're working for legally. And so that requires offer letters, employment agreements, independent contractor agreements, everything like that. And then from a stock purchase, or if it's an LLC, a membership interest purchase, there is more ease of transition because you don't have a change of who the employer is. So you have the same employer, but there still may be considerations where you may need to have new employment agreements or offer letters or independent contractor agreements, because there may be changes in the terms of employment, which doesn't mean necessarily that it's a bad thing. We'll talk about how we can positively impact employees and independent contractors and align their interests with the transition. Because from a buyer's perspective, one of their biggest risks is making sure that they can retain the same talent that's brought the business to the success that they have. And from a seller's position, one of their biggest concerns is making sure that their employees are well taken care of. There's a way to make sure that all of this works. And thinking about this early on, whether you're a buyer or seller in the LOI stage, will set you up for success for the entire transaction. I'm working on an LOI now where I was talking through the transition and saying, well, if you have a key employee, you don't have to do this. I was talking with a buyer, but it is beneficial to align interests if you have a retention bonus that's paid, let's say, at 6 months and 12 months post-closing for certain key employees to make sure that they're retained or for all employees. And sometimes that's something that sellers want to negotiate so that their employees are taken care of. Typically, that's pretty mutually beneficial. Of course, there has to be cash flow to support it, but for the most part, it's beneficial for all parties if the employees have some sort of incentive to continue and transition with the business. That's a very important consideration to make at the LOI stage so that it's clear between the parties what the expectations are with employee retention, independent contractor retention, and pay, especially with respect, and benefits, especially with respect to key employees and employees that are necessary for the continued success of the business. Certain employees are a lot harder to retain and also, if necessary, replace by refilling that position if something were to happen post-closing. So typical provisions that I see in an LOI are that the all employees will be either retained at the same or similar pay and benefits that they have been, and then sometimes also that the buyer has the right to enter into key employment agreements or offer letters or independent contractor agreements with key employees. So those are your typical, but of course it's going to depend from situation to situation, business to business, deal to deal on particulars of that. Let's talk about a little bit more of the consideration and complexities of employee transition. So employment law is at the heart of course, anything that you're going to do with employees. Now, that is going to be both with respect to making sure that that's covered in due diligence. Your attorney will help you review employment issues to the extent that there are any. Now, it depends on the deal size. Usually deals under sub 5 million aren't going to have compliance reviews, but if there's a deal that warrants it, they may include compliance, employment law compliance in their due diligence. Most of the time, the issues that you're due diligencing is what are the employee rights? What are the employee policies, benefits? What are the handbook and the rules? Are there employee issues, etc.? So not doing a complete compliance review, but really hitting the key areas of understanding the employment relationships and how those impact the business. And then a few aspects to also consider are a lot of the employment laws that are going to impact any sort of transition or any sort of employee rights. So those may include your union agreements. Right now, I'm working on a unionized deal, and that's actually not super uncommon. I think people think that unions may not be as common, but actually, given the amount of mergers and acquisitions that are in licensed or highly skilled areas, there are a lot of unions that you tend to see. So it's something that we have a lot of experience with. Then you also have to consider compliance with WARN Act if there's some sort of transition. So you want to make sure that you're working with your attorney and communicating on all things employment law necessary for the transaction. Thinking about buying a business? Unlock the secrets of successful acquisitions with Acquisition Insights, your legal roadmap for success. With over 81 modules of video lectures, written materials, guides, and checklists, we provide in-depth guidance to navigate every step of the process. From initial interest to closing the deal, get the expertise you need to make informed decisions. You can also access our battle-tested templates in the Acquisition Insights course and templates bundle, including our template LOIs, letters of intent, pre- and post-LOI due diligence request list, material deal terms lists, and more. Visit lauradifrancesco.co/the-shop today and take the first step towards buying your dream business. All the links are in the show notes. A couple other keys to success are proper timing and communication. So from a buyer's perspective, they're going to want to talk to key employees prior to buying the business. Not all the time, but a lot of the time that's important. From a seller's perspective, this is a confidential transaction. They may not want their employees knowing about the transaction until after the purchase agreement has been signed or after the closing has occurred. Now, it's really hard to kind of make sure that those all align, and making sure also that your LOI is clear on due diligence, whether the buyer has the right to contact employees, to speak to employees, customers, etc. So, from the buyer's perspective, they want to do that sooner rather than later. But from the seller's perspective, that most of the time they want to have that later. So typically what we would do in that situation is structure it so that a purchase agreement is signed, and then after the purchase agreement is signed, then both parties feel comfortable that the deal is going through. At that point, usually a commitment letter has been received, and then the buyer can start speaking to key employees, because most of the time, if there are key employees, the buyer would need the key employee to sign an employment agreement or offer letter or something of that nature to include retention bonuses or something to that extent. They may also include in those employment agreements that the employee will stay on for a certain period of time post-closing so that they have comfort in the security of the business. And then they may also include that certain transition notice needs to be provided if they plan on transitioning out of the business. So those are a few things that you may see. All of those should be in the LOI. If there are an issue between the parties, it's going to be an issue for most businesses, as most businesses do include employees. So purchase agreement is generally the fair spot to land on in terms of timeline of when to approach it. And even after the purchase agreement is signed, it may just be that only key employees may know, and they may not want their entire workforce knowing. Most sellers do want to tell their workforce pretty close to closing or leading up to closing so that there's transparency and trust and so that they can explain. But that is something that needs to be talked about between the buyer and seller to make sure that they are aligned on what the communication strategy is, who's going to be involved in it, how it will go. And then as the buyer, you also want to start planning your few days prior and after to closing. So after closing, it's definitely generally not going to be on the day of closing because that's really focused on actual closing. But typically on the day after closing or something like that, they would have a meeting with the company and then start that transition period of starting to get to know their team members. So taking the first 30, 60 days to meet with every one of the team members, get to know everybody, really start to have an opportunity for them to be heard. And most of the time, one of the biggest things to really reinforce at that stage is making sure that they feel comfortable that they have job security, that there aren't going to be transition changes that they won't be able to keep up with, whether that's rapid implementation of technology or otherwise. So a lot of times we have talked about transition in the past. You do, as a buyer, want to take the first 60 to 90, most of the time 90, sometimes 120 days to really absorb and learn and become the leader before making substantial change. That way you have the data and information necessary and can get the buy-in necessary to make change in the business successfully, which is ultimately, if you make change but it's not adopted, then it's not going to be a successful change to the business. Instead, it's going to be a waste of money. So you want to make sure that you have buy-in from the appropriate team members that you need to throughout that transition period. And then they're also going to be concerned about their pay, benefits. So having conversations about those, whether there's going to be adjustments or not, having conversations with the buyer and seller, and then also with the employees so that there's comfort level there is important. And when you're, especially when it's an asset purchase, sometimes the employee benefit plans are not purchased. And then the buyer sets up their own employee benefit plans, which are separate and different. And as long as employees feel that there's a fair transition there and it's well communicated, typically that's not an issue, but it is a concern from an employee's perspective that the buyer and seller would want to make sure is adequately communicated well. And then the next item is managing company culture. So of course you want to spend as the buyer the first 60 to 90 days really understanding company culture. And this will be different whether you're a first-time buyer and this is the only business that you own, or if you're adding on this business into an existing portfolio of businesses, and really understanding where companies align and where company culture differs. So I think sometimes, especially buyers coming in, think that they know better. And actually, a lot of the time, they may not, because there's just a lack of experience in the business. And trial and error may have led to things being done the way they are. For instance, I know of a friend who works at a local mountain who was bought out by Vail. And Vail has all of these security procedures and all of these rules and regulations to keep things safe. But in fact, actually, their standard of keeping things safe is so far below what the local mountain's security measures are, because they had so many practical things and aspects that they did to actually keep the mountain safe and keep the workers safe too. And so, for instance, just practical things of they would always keep similar teams. Like they would build a team and then they would always put the same team on the same shift. And so there was ease of working together, ease of communication, especially in really high intensity situations where someone's hurt, we need to respond, we need to get there quickly. Everybody had been working together on that team. It was established at the beginning of the season, and then they continue working together, and they have built communication. So, when you're thinking of, oh, we're going to implement all these standards, we're going to get culture aligned, we're going to make all these changes, it's important to really understand what changes you're making and the impact that it has. And actually, from a logical perspective, is it better? And there's a great opportunity actually here to learn. I love travel and I love learning languages and learning about others and taking the best of everything and making it all better. And I think that's why it's so important to have that great 90 to 120 day period where, as the buyer, you're really learning, observing, and understanding what's going on and why. And then you're saying, okay, this is actually a best practice that we need to, if you have other businesses, that we need to incorporate across all of our other businesses. And actually, we're adopting what they're doing because that's a best in class practice. Instead of just saying, oh, you're coming into the fold, come on to our culture, come on to our rules, how we operate and everything, without any consideration that actually you might not be doing it the best. And actually this business might have a lot to teach you. So I think that's really important as a buyer to consider as you're thinking about employee transition. And this whole process will be evolving from your due diligence to your communication plans, to the contracts that are drafted, and how you're able to be fair to all employees, independent contractors, and really build something together, because there's a lot that you can do when everyone's aligned. We talked a little bit about some labor laws. Of course, in due diligence, if there's employment agreements, independent contractor agreements, union agreements, all of those will be reviewed. And you want to make sure that you're able to comply with those. And if you want to bolster them, change them, update them, you won't be able to do that with a union contract, but perhaps like a key employee contract, then you have the opportunity to discuss with the seller that you'll need to obtain that prior to closing, and then that would be a condition to closing. Especially in a licensed business, we had an episode prior to this about licensed businesses, especially in licensed businesses where certain key employees hold those licenses. That will be extremely important for the continuity of the business. And I think both buyer and seller can agree to that. Another wrinkle is how to address family members and people who may be employees of the business who are not necessarily actually the best fit for the role. So those all should be discussed early on in the transaction, whether that be at the LOI stage or into the early due diligence phases, so that it's clear by all parties how those will be handled and whether there needs to be transition plans or whether there's any assets or benefits that need to continue on for certain people post-closing for a certain period of time to allow transition. Sometimes you see if a seller has a spouse that's on, maybe they'll be on as an employee for a couple months to transition them out of the role and find a good replacement, but ultimately they weren't necessarily the best fit for the role. They may have just been there to provide an income for their spouse or an income for their parent or something like that. So all of those considerations are slight wrinkles that you'll want to address throughout the process to make sure that there's complete transparency and that everybody's aligned on expectations. And also know, as the buyer, as the seller, that your employees are key stakeholders in this transaction. They can easily influence the transaction. So it is very important that it be a fair and mutually beneficial relationship and transition. When it comes to navigating corporate law, entrepreneurship, and managing small businesses, experience matters. Dean Street Law is a boutique corporate firm specializing in mergers and acquisitions, and additional focus in real estate, commercial transactions, finance, and corporate governance. With over $10 billion in deals closed, Dean Street Law has extensive experience representing hundreds of clients in thousands of transactions, from small businesses to Fortune 500 companies. Whether you need startup guidance or advice on closing multi-million or multi-billion dollar deals, we're your trusted partner every step of the way. Visit deanstreetlaw.com in the show notes to schedule a complimentary consultation. Now, executives tend to be those key employees, and sometimes banks and lenders will require key man insurance policies or key employment agreements or key independent contractor agreements in place so that they feel like there's a level of security with continuity of the business from an employment independent contractor labor perspective. So those may be very different and should be very different than your traditional employment agreement or whatnot. It should all be scaled to match. So if you have a team where they haven't had employment agreements, if you put 20-page employment agreement in front of them when they haven't had an employment agreement, that's just not the right scope. And that's where I've seen some people go wrong in terms of not adjusting contracts. So I see a lot of people where they work in private equity, they work in investment banking, they tell me they have all of these templates that they want to use, but they don't realize that when you're applying these same contracts to the business that they're pursuing or something like that, they just don't match up. So you don't want to have a 20-page executive employment agreement be for a general manager that's never signed an employment agreement for. Maybe a 5-pager, 3-pager, an offer letter that's 2 pages. That would be more appropriate. It can still cover the things it needs. Yes, when you have executives, there's going to be a lot more potentially covering severance or whatnot. But for the most part, you want to keep it as simple as possible. And just because we have templates that private equity has used does not mean that those are the templates that should be used in the business. You really have to make sure that it makes sense and it scales for the business that you are working with. That's one of the biggest mistakes that I see, especially because people don't really understand how a $50 million deal or even a $15 million deal is different than a $2 million deal. You really have to have experience in all of these phases and all of these different size deals, which we do, to be able to actually say, this is appropriate. This isn't going to scare the employees. This is going to be best for everybody. And when you're going through your due diligence with executives, you want to think about compensation structures. We talked about retention strategies and then aligning incentives and goals. And then sometimes people are thinking of like, oh, well, I need to give them stock to align employee incentives. Actually, for the most part, stock isn't very incentivizing for many people. That's like saying, well, let me give you $10,000, but you won't see it for maybe 5 to 10 years if you see it at all. So actually, it's just going to be something that looks good on paper. Most of the time, stock is not the way to go to incentivize and align. If you wanted to give equity, phantom equity is better. It's not going to dilute your cap table. It's going to make things a lot cleaner and easier. But at the same time, I think most people just really overlook how easy incentive pools and bonus structures and everything can be. And that actually incentivizes most people much better. And it actually costs way less, way, way less. So for the most part, those are going to be the types of incentive alignment that you're looking for. Be very, very careful about adding people to the cap table, especially if you haven't worked with them for years. It's a really dangerous place to be. It's a lot harder to recoup that equity than even if you have mechanisms for it. It can be a lot harder and a process than it should be. Whereas if you have really clear incentive bonus pools and whatnot, that can be a really straightforward, easy way to make sure that you don't have to get sign off every time you do a major business transaction or get consents from everybody or get a vote from everybody. So those are really important to consider. Now, sometimes equity does make sense, especially when you're using someone's license or something like that to operate the business. That make more sense. Or if you want a manager who you have faith in, you have a business relationship with, that may be different. But I do think that especially waiting until you have a relationship with someone to grant equity is an important consideration when you're thinking about the ramifications long-term of that decision. And when you're thinking of those and building out your labor for your business, you're going to be thinking through assessment of skills, goals, how you're looking to grow the business, what the current size of the business is. But as I said, it's more important to get into the business as the buyer, learn about the business, and really understand what's going on before making any significant plans to grow, scale, change the business. And then severance agreements are generally only going to be applicable to executives, but they may include liability releases, which you have to be very careful of, termination terms, which are one of the most important things to include in any key employee or independent contractor relationships. And then, of course, benefits, whether that be PTO, vacation, and then whether outplacement assistance would be provided. We talked about addressing the employee benefits, and then as one of the laws that you have to make sure that you're complying with, COBRA would be another, but you're going to have a conversation with your lawyer about all of the legal compliance. A few of the other legal compliance considerations are going to be tax implications, securities laws, and how those retention incentives play out from a legal perspective and from a tax perspective. So I hope this has been a good summary, a quick intro to how to plan a successful employee transition, whether you're a buyer or a seller. There's tons of information in here for both of you. It would mean the world to us if you subscribed, leave a 5-star review, and be sure to share this with a colleague or friend or anyone you know who it might benefit. That is the greatest compliment you can give, and I will always love to know what you'd like to see in the next episode. How can we help? The goal is to help buyers and sellers both be better prepared for mergers and acquisitions so that it's an easy breezy process. And of course, if you'd like to work with us, we'd love to learn more about your transaction, and you can schedule a complimentary consultation with us at deanstreetlaw.com. All the information is in the show notes. I'll see you in the next video. Thank you so much for joining us on this episode of the Dealmaking with Laura DiFrancesco podcast. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of mergers and acquisitions. If you enjoyed this episode, please be sure to follow and subscribe to Dealmaking with Laura DiFrancesco on your favorite podcast platform so you never miss an episode. And if you found value in our discussion, please leave a 5-star review. It would mean the world to us, and share this podcast with your network, friends, and colleagues. For more in-depth resources, be sure to visit our website, deanstreetlaw.com, where you can find articles, guides, and more information on our services. Don't forget to follow us on social media for the latest episodes, updates, tips, and exclusive content. You can find us on LinkedIn, Search Funder, at LMDFrancesco on X, and at Dean Street Law on Instagram. Join us on our next episode where we'll explore more deal-making insights. Cheers and happy deal making.